right, welcome back, everybody. President Cyril Ramaphosa's application for an urgent judicial review of the Public Protector's Bosasa report is scheduled to be heard today in the North Gauteng High Court. The president has accused Busiswe Mkhwebane of unlawfully obtaining some financial information regarding his CR17 campaign and leaking these to the media. In her report, Mkhwebane found that Ramaphosa had misled Parliament and violated the executive member's ethics code in relation to a R500,000 donation that his campaign received from Bosasa. Well, joining us in studio, we've got Bulelwa Mabasa, a constitutional law expert and attorney, to explain to us what the legal process for the president's application is. Also, political analyst Xolani Dube from Xubera Institute of Research and Development to talk to us about what this means for the president. Both of you, thank you so much. Good to have you in studio.
It's a great pleasure to be here.
All right, so let's start off with what the process is that we can expect today out of the Pretoria High Court in this President's judicial review.
Look, I think it's important to state that review proceedings have within them a mechanism where the party that's launching the review has an opportunity to get documents, which is called the record, that the decision maker used in making a decision. So what has happened now, there's an interlocutory application, this is an intervening application that the president launched to say that the documents that were acquired were illegally acquired and that they should be sealed from the record. This is very common in review proceedings as part of Rule 53, which is a rule that governs this, where parties can say, look, certain documents must be saved from production from the public because they're confidential, because of national interest issues. So the issue here that the president is arguing is that those documents were illegally obtained and therefore should be protected from public production.
Let's talk to what's happened over the weekend, though. We've seen some leaks happening to the media. We saw some publications coming out yesterday with a lot of that information. Has this hampered what we're about to see happening in court?
Look, I think to a very large extent it has, especially to those parties that are not even parties that are cited in this application. So you will recall that this application is between the president and the public protector. But what these leaks have done is that they have now also ended up in production of confidential information of other third parties, which is what the rules of court generally would protect against. So in other words, the rules of court will say information that will hamper parties that are not before the court must be protected from production. But because of these leaks, the information has now been, it's now in the public fore. Yes.
Yeah, and it's a big deal. Xolani, let's talk to what's actually happening here. I mean, this court battle, can one assume that this is completely politically motivated?
I think this speaks mostly to us, especially the Africans, post-apartheid. And we need to confront a very uncomfortable question: if the Africans are really fit to govern. Because if you have noticed, post-apartheid, it seems as if we Africans, we are really in a serious dilemma when it comes to governance, and especially from the governing party. And if you understand the historical conception of this governing party was based on fighting the injustice. But if you look at the way that they do things, they are no longer at that, I can say, respecting that call to fight the injustice. When you look at the issue of marijuana, when you look at the issue of the arms deal, and when you look at the issue of Kolobeni as we speak, it really shows that it seems as if the governing party is not having the interest of those people that it was conceived to liberate. And it seems as if now the so-called the political elite, they are having what you call it an inward looking. They are no longer looking at the interest of those that they thought that are really oppressed. And so I think that we are having a dilemma, because we can't govern a country through court processes, through commission. And that shows clearly that there is an issue of governance that we need to confront, especially the black people in this country.
I'm struggling to understand a little bit more about what you're saying, because just in terms of this particular case, is it politically motivated? Do you think it is, or do you think not?
Look, you know, the issue of political motivated or not, I think is far-fetched here. We are talking about transparency. We are talking about openness. We are talking about knowing who are these people who are handling our politicians. Because once our politician is having it or is being handled by external forces, we have seen it with Babu Jacob Zuma, and the whole world, especially here in South Africa, we were alarmed that how come that a president of our country can rule this country at the behest of an external family. And now again, we are seeing the similar thing through these leaks, as if our president is serving at the behest of those who paid his way to become the president of our country. And so, as I've said it before, it seems as if the ANC has been twisted to become a Trojan horse for external forces in order to scramble the resources of our country, of which is a very sad part.
Let me ask you this question. Is there any difference between what we're seeing happening with the now president, Cyril Ramaphosa, and what happened with our previous president, Jacob Zuma? Is there a difference?
The problem is not these individuals. The problem is the institution that produced this individual for the South Africans. And so I think the real prognosis that we need to look at is the relevancy and is the historical mission of this institution. If this institution is still really relevant to take us forward, or this institution has fulfilled its mandate but is no longer relevant to take us forward to the new, what we call it, new life in South Africa. Because the way things are happening, it seems as if they've run out of the ideas, they've hit the wall, and hence you can see that they're becoming weak and weak each and every day.
All right, Bulelwa, let's talk a little bit more to what's happening in the courts now, because we saw the presidency actually before the Sunday papers came out. We saw them releasing a statement on Saturday night as well, coming through and saying, expressing grave concern and saying that the report is in violation of the constitutionally enshrined right to privacy. Is this argument valid in court, though? Because, you know, these leaked documents, surely some of that information, or the majority of the information, obviously not bank account numbers and details, but the majority of that information is in the best interest of the public.
Look, I think it's important to establish what is before the court and what the court has to decide and review. The court has to decide whether or not the public protector's decision is reviewable. So the documents that were leaked in the media, ordinarily, if this was an ordinary review application, parties get together and parties agree on which of those documents can be made publicly available. As I've said, if there's documents that are being published but that have an impact, an adverse impact on other third parties, like for example the donors, then those people's rights would be prejudiced. And such, it's not so much that the information is not in the public interest, is that if it's published, it will adversely affect the rights of other third parties that are not before the court. So it's important then that it's understood that the request to seal documents is quite a common practice that happens every day in court cases and reviews like this, where parties decide which information will only be known by the courts and which information can be known publicly. So the application to seal the evidence is not for the court not to have the information, but rather to protect the identities of those people who are third parties that are not necessarily subjected to the court process.
Now, if it is found that the public protector did in fact obtain this information and documents illegally, what happens then? It
means that the evidentiary burden, or rather the importance that's placed on that information is scrapped. In other words, that information cannot be taken into account when a judge makes a decision. So no evidence can be relied upon information that has been illegally obtained. But of course, then the implication of that is that there is a public perception issue that cannot be cured by the legal issue, if you understand what I mean. Is that publicly there is the perception that the president is trying to hide something will persist, even though legally that information may not be relied upon.
Yeah.
So there's a court process on one hand, but there's also the court of public perception on the other that can be damaging.
But how far is the public protector legally allowed to go to obtain these documents? I mean, when we talk about obtaining something in an unlawful manner, how? If it's given to her and said, here we go, these are the documents,
so
is that
usually
illegal?
With information such as bank accounts and that is personal, that is protected information, you've got to obtain a subpoena or some kind of a court order in order for that information to be legally obtainable. So the lawfulness or how you've obtained information that you can rely upon in a legal process is as important as the substance of the information itself. And so when you ask how far can the public protector go, of course she's got powers, investigative powers inherently in the statute that governs her conduct. But she is not at liberty then to obtain information unlawfully and or to use the information in an unlawful manner.
Yeah. I mean, Xolani, we look at this and we really are, it's very difficult not to see the factionalism within the ANC not being played out here. Again, talk to me about this. I mean, you know, these accusations and what's happening now, you've got the Zuma faction, the Ramaphosa faction, we all know that this is existing. But is this sort of the Zuma faction getting the upper hand here?
I think they are equalizing the equilibrium here because the public perception with those that were in the Zuma camp was that they were really the rogues of our nation, were the people that need not to occupy the honorable office in our country. But what they've done, they've created a catastrophe for themselves in the ANC as well as for the country. And in that catastrophe, Cyril Ramaphosa becomes kind of a victim to a certain extent, because now when you go to these NEC meetings and also to the public eye, it's no longer that Cyril that was portrayed before his ascendancy to the highest office of someone who is on the high moral and ethical leadership. Now is someone who's equal to the rest. And so now they are going to co-govern with him as well in the ANC as well in the country. And so Cyril is no longer going to have that dictatorship of morality and ethic. And so I think to a certain extent, if we become, use the conspiracy theory, they've managed to clip his wings and also to make him similar to them. And so, but on the other side, you have to bear in mind that he's no longer going to, how can I put it, he's not going to be the Cyril that we thought that he was supposed to be. And he's done. I mean, he's so compromised. He's a lame president for the next 4 years.
All right, Bulelwa, you don't look like you agree here.
I disagree because I think we need to distinguish between public perception issues and legal issues.
Right.
Legally, there has no law that has been breached. Legally, there's no law in South Africa that prevents a presidential candidate from obtaining donors for a campaign. So we don't have legislation that has been breached here.
Which is important to note.
It's a very important, important thing to note. And somebody else can say, well, you know, what are the ethics or the principles around this within the ANC camp itself? And I think another important thing to note is that we had various presidential candidates, hopefuls, who also had their own, public donor campaigns, but those are not subject to scrutiny. So I think it's important to create it, to communicate that legally there is no law that has been breached. What has happened here is that we now have a glimpse into those people that have donated into the presidential campaign. I think it's quite a separate question to ask. Well, what should happen in the future? What kind of transparency is required in terms of knowing who donates to political parties? It's not just an ANC thing, but I think it's a discussion that needs to be had for the future on how political parties are funded. But when it comes to this particular case on its own, I think it's important to note that there hasn't been a breach of any law per se.
Very quickly, what does the law stipulate? I mean, many people are talking to the party political funding and this bill, and we know that it exists, but you know, when we were seeing the amounts of money that are being donated to this particular campaign, I mean, we're talking tens of millions. Is this legal?
Look, I think it is legal to donate, to raise funds for political purposes, for political party purposes. The question that we should be asking is whether or not how the close proximity between those that fund public officials and elected officials, and whether or not those people stand to gain and benefit from the proximity of that. But I think, like I said, this is not what the court is seized with at the moment. And this is something that has to be threshed out in the future in a form of some form of legislation, like the bill that you've just mentioned.
Morality comes into it, and we do see that some of these donors are already benefiting from government. And I mean, to give those large amounts of money, and this is not the law, and I know that you're talking from the law perspective, but a lot of these people that have been named in these leaks have benefited.
Look, what is very important, we need to separate the law and the reality.
I think that's difficult, though, isn't it?
The political perception, because the ANC has got its own governing rules. And when it comes to electing people, it's written there in the ANC that people must not use money in order to ascend into the highest position. It's there. If ANC has agreed that people can go out and fundraise, this was not going to be an issue. It's an issue because in the rules of the ANC, people are not supposed to do that. And even beyond that, we have to be very careful, because currently there is a law that has been passed in our country where there must be an openness on those who fund political parties. And so in this case, in the internal processes of the ANC, if people were allowed to go out and source funding, this was not going to be an issue. And I don't think that we're going even to have this court case today where Cyril Ramaphosa was going to plead, saying that those donors or this document were sourced illegally. And so the issue is a very simple one. It's the issue of morality, and it's the issue of politics, because we as South Africans, we need to know, as I've said, who really handled this politician, because the one who fund this politician at the end of the day are the one who will be benefiting, and as South Africans will be left stranded.
Okay, Xolani, we've got to leave it there. Thanks for the robust discussion, both of you, for giving us two perspectives. Xolani Dube, political analyst from Xubera Institute of Research and Development, and Bulelwa Mabasa, constitutional lawyer and director of Worksman's Attorneys. Thank you. Thanks, both of you. Right, we're running a bit over. It's 7:02, but let's get into the news bulletin.